Welcome, everyone. My name is Susan Albertine, and I'm a member of the League of Women Voters of Montgomery County, Maryland, a nonpartisan organization that does not endorse candidates or support political parties. In accordance with our mission to empower voters and defend democracy, we sponsor webinars to inform the public on important issues. The League of Women Voters has supported passage of the Equal Rights Amendment for decades, as we contend its ratification will support legislative efforts to further gender equality. Its proponents also believe it would permit the courts to analyze sex-based discrimination cases more effectively. But exactly how could this be? And does the ERA as written still leave gaps? Tonight's panel will tell us more, and an audience Q&A will follow after their presentations. But first, some housekeeping details. This webinar is presented by the League of Women Voters of Montgomery County. The meeting is being recorded and live streamed. The recording will be made available at a later date. Be sure to subscribe to our YouTube channel and follow us on Facebook, Instagram, and Twitter, turning on all notifications for the latest updates. The audience will be muted during the webinar, and the chat box has been disabled for attendees to minimize distractions. After our speakers make their presentations, we will have a Q&A session. Questions will be visible as they are answered. We encourage you to ask questions, but want to remind everyone to be respectful of our speakers and each other. To submit a question, click on the Q&A button at the bottom of your screen, type your question into the box, then hit send or return. We will answer as many questions as time allows. The program is scheduled to end at 8:30 p.m. Now, I am pleased to introduce tonight's speakers. Jessica Jones Capparell is the Director of Government Affairs at the League of Women Voters of the United States. She manages strategic planning in the organization's lobbying arm to generate public support on issues important to the League. We were hoping to have Christian Nunes from the National Organization for Women. Unfortunately, she is unable to be here tonight. And finally, Brandy Faulkner is the Gloria D. Smith Professor of Black Studies and a collegiate assistant professor in the Department of Political Science at Virginia Tech. Her work focuses on constitutional and administrative law, race, public policy, and critical organization theory. Now, it's my pleasure to invite Jessica Jones Capparell to begin tonight's program.
Thanks so much, Susan. I'm just going to quickly share my screen. Okay. I think we're good. All right. Thanks so much, Susan. I'm excited to be here with you all tonight. I am a Montgomery County League member, as well as a member of the LWVUS staff. So I'm very excited to be here with my home league. And I see lots of familiar names on the participant list. I'm going to talk a little bit about the League and the ERA, our history and our work. Before we get started, though, I just want to make sure that people have seen the ERA. So the ERA is very simple, three different clauses. It reads, equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. And I know we're going to hear more later from Brandy about the language and some other things as well. So we'll dig into that in a couple minutes. It also gives Congress enforcement power. So making sure that they have the right to and power to enforce by appropriate legislation the provisions of the article. And then it sets when it's supposed to be to go into fully effect. So 2 years after the date of ratification, which technically was January of 2022. Oh, I'm sorry, I skipped a slide. Oh, and you can't see the one I skipped, so it doesn't matter. So a little bit more history and background. Of course, the constitutional amendment process is established by Article 5 of the U.S. Constitution. Typically, Congress will file a joint resolution with a proposed amendment, which then must pass with a 2/3 majority in both houses. The proposed amendment then goes to state legislatures or to the people, where 3/4 of the states, which currently is 38, must ratify it. And as Article 5 says, when an amendment meets the 3/4 state threshold, it's a valid part of the Constitution. Once that happens, the National Archivist, who leads the National Archives and Records Administration, certifies that the amendment is valid through a formal proclamation. And so 2 years after ratification, the ERA should be in the Constitution. In 1972, so more than 50 years ago, excuse me, Congress passed the ERA with well over the necessary 2/3 vote that it needed. And in January 2020, Virginia became the 38th and final state needed to ratify it. Of course, our other states can still continue to ratify it. As the ERA has met all ratification requirements, we're now more than 3 years from ratification, meaning we've passed the effective 2-year waiting period. The calls continue for formally completing the amendment process and officially recognizing the ERA as the 28th Amendment. And now, sorry, my notes are not moving at the same speed as my slides. So why isn't the process complete? Here we get into an issue of a time limit. When Congress passed the ERA in 1972, it included an amendment preamble, which established a 7-year time limit for states to ratify. And in 1978, Congress extended the time limit by 3 years. But then in 1982, when the time limit came up, ratification of the ERA was still 3 states short. But then we all know that in 2017, Nevada ratified, in 2018, Illinois, and in 2020, our neighbor Virginia ratified, making the 38th state needed. The end of 2018, ERA ratification was just 1 state short, and the National Archives, the end of 20. Anyway, ERA ratification was just 1 state short, and the National Archives and Record Administration contacted the department, this is after Illinois ratified it, contacted the Department of Justice's Office of Legal Counsel, or the OLC, for guidance on what the archivist should do in the event that a 38th state should ratify it. And in January 2020, under the Trump administration, and unfortunately all things are political nowadays, the OLC did issue an opinion, and it said that Congress had the constitutional authority to impose a ratification timeline when it passed the amendment in the 70s, but it may not revive a proposed amendment after its ratification timeline had expired. The office said that because 3/4 of the states did not ratify the ERA before the timeline, the ARA is no longer pending before the states and could not be certified. And then 2 days later, the archivist released a statement saying that it defers to that opinion of the OLC, meaning the archivist at the time wouldn't certify Virginia's ratification that year unless otherwise directed by a court order. In January 2022, 5 Congress members sent a letter to the OLC urging them to withdraw that 2020 opinion. And I think that everyone thought that because there had been a change in the administration from President Trump to President Biden, that the answer would come back differently. But the OLC issued a statement saying that they maintained their previous opinion, but that opinion did not preclude the judicial branch from considering the constitutional status of the ERA, it also did not preclude Congress from acting on ERA ratification. And shortly after that statement came out, President Biden issued a statement calling on Congress to pass a resolution recognizing ERA ratification. So I know that's a lot of background, but that's also a large part of what's informed our advocacy strategy around this very important amendment. And this is important because sometimes ERA advocates disagree on strategy. Some constitutional scholars, which I am not, specify that Congress doesn't need to take action because, as we've discussed, all ratification requirements have been met. So it is a valid part of the Constitution. And some of those folks have put pressure on the administration to push the archivist to certify the ERA. The League has made an ask to the president to direct the archivist to publish the ERA, but strategically, we've decided to focus our advocacy efforts on Congress because the OLC and President Biden have continuously pointed to Congress, and Congress is currently considering a good solution. There we go. So the League's work on the ERA, as with all of our advocacy issues, is rooted in impact on issues, which is our League positions that are derived directly from our membership, adopted through a very sometimes long process, program planning, and adopted by our members at convention or annual meetings. This happens at all levels of League, as you all know. And the League, the specific position that guides our work on the ERA is our equality of opportunity position. The League supports equal rights for all under state and federal law, regardless of sex, race, color, gender, religion, national origin, age, sexual orientation, or disability. We support ratification of the ERA, and we support efforts to bring laws into compliance with the goals of the ERA. At LWVS, we do our ERA advocacy work in coordination with the National ERA Coalition, and we've pushed for ratification since it was first passed by Congress in 1972. It's also a position that our members have time and time again supported at the National Convention. In both 2020 and 2022 at the National Conventions, delegates voted to add the ERA to the LWVUS program. And as you can see on the screen, the program additions are pretty similar. The first in 2020 included it with urgent issues like climate change, healthcare, gun safety, and immigration. And in 2022, they moved it as an individual program item so that resources and focus be used to accomplish the passage and further our mission. Ooh, sorry, one too many. So this brings us to a congressional solution. There is a joint resolution in Congress that affirms that the ERA is a valid part of the Constitution, and that addresses the question of a ratification time limit. In the Senate, in the 118th Congress, it's SJ Res 4, which has been introduced by Senator Cardin and Murkowski. The Senate Judiciary Committee held a hearing on the ERA at the end of February, and Senator Schumer today has said that he will place the resolution on the Senate calendar for, this presentation used to say month, but it will be this week. We expect closure to be filed on the bill tomorrow and a vote to happen on Thursday on the floor. The resolution's text is identical in both chambers. There's also a House version, HJ Res 25, which has been introduced by Representative Presley. Carolyn Maloney, Congresswoman Maloney was a longtime leader on the ERA, and she was primaried out of her district in the last election. And she has passed the mantle over to Representative Ayanna Presley, and we're grateful for her leadership in the U.S. House. The joint resolution is similar to the one that was in the 117th Congress, in the last Congress, which also addressed the issue of a time limit and passed in the House with bipartisan support. It did not get a vote in the Senate, but of note in the Senate, it was co-sponsored by the entire Democratic caucus, as well as Senators Murkowski and Collins. And I will note that Senators Murkowski and Collins are also on this version of the Senate bill. And so we're very grateful for their bipartisan support in the Senate. To give you a sense of the League's ERA federal advocacy strategy, I'll quickly go over our top lines from the 117th Congress. So in 2021 and 2022, LWVUS included the ERA in its priorities to the new Biden administration. We also sent a letter to members of the House urging support of their resolution and released a press statement commending its passage. We sent a letter to the Senate urging support of their resolution and released a press statement commending President Biden's Women's Equality Proclamation that expressed the need for the ERA. I know that we have several members of the LWVUS Lobby Corps on this call, so I'll also call out that the Lobby Corps has been working side by side with LWVUS staff to lobby and to get senators and representatives on board with this resolution. And so I thank them very much. We're always very grateful for their help. We also sent a letter to Senator Schumer urging him to schedule a Senate vote on the resolution. We weighed an executive branch option by sending a letter to the White House Gender Policy Council and urging them to advise President Biden to instruct the archivist to publish the ERA. Additionally, we worked on a long-term initiative in which state leagues wrote to their senators on the resolution, and then we sent a package of those letters again to Senator Schumer to demonstrate nationwide support. And we have utilized an action alert for the Senate legislation. So as you can see, we've done executive advocacy, emphasizing the need to prioritize this issue. But again, our focus has been garnering co-sponsorship and votes in Congress and actually trying to get that vote scheduled in the Senate. Sorry. So for the 118th Congress, which just started and feels like it hasn't even begun really in some ways, we hit the ground running in February. First, the day that Congress publicly announced the joint resolution in both chambers, we published an action alert, which has been very successful, garnering over 6,000 letters to the Senate in just a short time. So people can urge their Congress members to support the current legislation. And we sent out an email to League members and supporters and utilized Outreach Circle with our League affiliates to maximize the reach of that action alert. We also submitted written testimony for the Senate Judiciary Committee hearing that took place at the end of February. In the past couple of months, we've been meeting with the bipartisan sponsors of the Senate resolution to talk about strategy and talk about where the League can best lean in to bring on more supporters. And that means we've been meeting with some identified senators who are Republicans to possibly get them to a yes, so that we can get to 60 votes when this vote comes up. We've also, again, begun to work on our letter writing campaign with leagues in those states. So what can you do? As we know, change is incremental, and oftentimes passage of major bipartisan legislation requires its reintroduction in multiple Congresses. It also might also require Leader Schumer to switch his vote at the end so that he can bring it up later again in the future. This is why we need to keep showing up and helping to demonstrate a track record for bipartisan support for this vital issue. And a lot of change starts with public education. I'm coming here today to discuss the ERA, understand its nuance, and identify ways to talk about it actually is a really important advocacy opportunity. So firstly, I pulled out some of the top line bipartisan talking points, as you can see on the screen. And those include the ERA will constitutionally protect the equality of rights under law, regardless of sex. The ERA has met all ratification requirements. Women continue to face discrimination based on sex, and that's clear in the ongoing fights against unequal pay, workplace harassment, pregnancy discrimination, and domestic violence. And then some bipartisan talking points on SJ Res 4. And maybe everyone here on this call doesn't need them because your senator, our senators are on board. And one of them is the sponsor of the resolution, but maybe you can use these with your friends. But on SJ Res 4, we know it's a bipartisan resolution. It's co-sponsored by Senators Collins and Murkowski, and it will affirm that the ERA is a valid part of the Constitution and address the question of a ratification time limit. And the biggest thing we can tell people is that nearly 75% of Americans support the ERA. LWVS also has resources for local and state leagues. And if you go to the league management site, LWVS has an ERA toolkit, which we recently updated with talking points, frequently asked questions, and graphics for social media and more. The toolkit includes a template letter to the editor and a friendly reminder that local leagues, should contact state leagues before contacting or calling upon their senators to take action. The toolkit also includes the LWVS action alert to contact your senators and representatives, which I can also make sure to send the link around for folks who want to take action. We can't do this without you. We can't do this without everyone talking to their friends and talking to their neighbors, even in other places that might need a push, and doing the action alert when we do another action alert later this week, because now we'll have a vote on Thursday. So I'm very excited to be here with you. And I'm also excited to hear from Brandy and to answer your questions later. And with that, I'll hand it back over to Susan.
Thank you, Jessica. Next, I'll invite Brandy Faulkner to present.
Well, thank you. Thank you so much to the League. All of your hard work and your legacy on this issue, among many others, has been so inspiring, I think, to a lot of people. And it matters, right? As Jessica said, the work matters. It really bothers me that in 2023, we are still having to demand equality, to demand equity, right? And when I think about everything that has gone into trying to get the ERA to become part of the Constitution, the first wave feminists who fought so hard, the second wave feminists who picked up the torch and kept going, I find myself getting really frustrated about this issue. Nevertheless, here we are, right? Still going, still fighting, and still doing the work that I think needs to be done in order to keep moving forward through the ups and the downs and the wins and the losses. In many ways, the ERA is unfinished business. And it's certainly something that I've thought about often, sometimes with a whole lot of hope, and then sometimes with some skepticism. I've studied the significance of the ERA and what it might mean for women specifically. I've reflected on what could have been done differently, how we could have had a stronger movement, maybe to get the ERA ratified. And I've also thought about what we can still do, right? Given that we are a century removed from Alice Paul's reality, we have a new reality for many of us. And what does all of this look like in 2023 and beyond? What is it really that we're trying to accomplish with the ERA, and how can we get it done? But I also think about how far we've come, right? We're no longer, for the most part, in the days of being valued only for how well we can cook and clean, right? So that's certainly a good thing, or how well we can take care of the home. Today, and in addition to being excellent spouses and partners and mothers, we are also in the boardrooms, right? We are in the operating rooms, we're in the courtrooms, and we're running for public office in record numbers. right? Many, many women who are trying to change the world, right? And can't be successful without having access to the resources that they need to do that. And yet, despite all of these achievements, despite being in a remarkably different position than we were in even 50 years ago, there is still a power imbalance, right? And that imbalance is preventing some of us from being able to reach our full potential. And that is why the ERA is so important. And, it's so simple in its language, shockingly so, I think, when you look at it, right? Equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. Why is that such a tough concept to embrace, right? What is really behind the fear? What is it that we are afraid of? And over time, so many reasons have been thrown out. Okay, so some would have us believe that we don't even need the ERA, right? Because over time, things just kind of worked out, right? Magically. Things are happening slowly but surely, and we ought to just wait and see what's going to come of those efforts. Let's not talk about the ERA. Let's not talk about the potential of the ERA. Let's just keep going and see what happens. And many people make that argument that maybe it would have helped somebody many years ago, but we don't need it anymore, right? And then you've got the slippery slope folks, right? Maybe most personified by people like Phyllis Schlafly, who really believe that if women achieve full equality, right? If women have access to the same privileges and benefits, then the moral fiber of the country will suffer. Right? We'll head down this slippery slope where women will no longer want to be married. They will no longer want to have families. And then what do? Right? What's going to happen to society? Right? They may be required to join the military during times of inscription, and what do we do then? Right? So there's this constant fear mongering around the ERA, and so to prevent the potential social decay that equality could cause, we should leave the ERA alone. Let's not worry about getting it passed, right? And this argument is always framed as though the rights of women belong to men to grant to us as women. Right? And of course, they do not. We are all born free. We are all born equal. And we are simply asking that it be recognized as a matter of law. That the barriers that continue to prevent our full participation in a democratic society be removed. Not some of them, all of them, every single one. So when I think about things like gender pay gaps, I can't help but wonder where we might be had the ERA been ratified decades ago. Right? Equal pay for equal work. Right? I really can't figure out what's so hard about that. But when we look at rates of poverty, in every single state, women are poorer than men. right? And nationally, right now, about 16% of women live in poverty compared to 11% of men. We have fewer resources, financial resources than men. We own less property, right? Fewer businesses, fewer economic opportunities. And this is true even as we are seeing an increase in the number of women who are earning college degrees, right? So there are surely many factors that contribute to that disparity, but one of them is this pay gap and the fact that women often get segregated into the lowest paying jobs, face glass ceilings. Many can't even afford to work. And it has been especially devastating to single mothers, right? And so it's really interesting because each semester I teach a course titled The Politics of Gender. And one of my students said to me when we were discussing this topic of pay gap, okay, I get it. Yes, women don't make what they should make. And maybe that's not fair. But at the end of the day, we're only talking about a 20 to 30 cents difference on the dollar. So why does it matter that much? Right? And with all of the grace of my Southern grandmother, right, I managed to bless your little heart. But this does matter. Understand that it's about more than just similar paychecks. It's about more than just being fair. There are very real economic consequences because of the inequality. The gender pay gap right now is at annual earnings, full-time employees of 18%. Right? That's very, very significant. And because of this pay gap, a woman will lose about $1.5 million in wages over her lifetime. That's $1.5 million that can be used to improve the quality of their life. That's $1.5 million that can be invested. That's $1.5 million that can be used to support children and family and community members. $1.5 million that men get just for being men. And so when we look at legislation that has tried to address it, beginning with the Equal Pay Act back in 1963, it has had some effect, but not nearly as much as was hoped. And so Congress had to come back in 2009 and pass the Ledbetter Fair Pay Act, and it's helping a little more, but we are still nowhere near where we need to be. And the ERA could make the biggest difference, right? So it matters. But there are surely some challenges to moving forward, some very real barriers, I think, that we have to address, because it's not just about what the laws say. It's not just about what the Constitution says. It's about how both are interpreted, right? And that will ultimately determine the success or failure of the ERA. How is it going to be interpreted? Not just by legislators, but also by courts, by public administrators who will be charged with implementation. And who's it gonna matter to most? And this is where some of my concerns over time have definitely come out, because ultimately we really just don't play well together. And I think that's such a real shame, because we could be so much further along if we did. It is a fact that the experiences of women who look like me, Women who come from my class background have been excluded from most of the discourse around sex and gender equity. When the ERA was first presented back in 1923 at the National Women's Party Convention, we weren't in the room. No one who looked like me was in the room. And as the rally to support the ERA continued year after year after year, we, as Black women, were still being excluded from that discussion. Women who were part of labor movements were being excluded from that discussion. So shortly after meeting with Alice Paul, as the amendment was being drafted back in 1921, Florence Kelley, who was a labor activist and a very, very prominent abolitionist and child advocate, publicly opposed the ERA, right? And you might think, how in the world could someone so progressive oppose the ERA? Well, much like the current iteration of the ERA, the original language was very, very simple. It read, men and women shall have equal rights throughout the United States and in every place subject to its jurisdiction. And as Paul explained it to Kelley in her communication, it meant true equality, identical treatment between men and women. And Kelley's work across global communities of people, especially in the arena of economic justice, she was seeing time after time after time how men were so advantaged in the labor market, but she was beginning to make some headway in terms of getting what most legislators consider to be special treatment for women, right? It's amazing to me how we sometimes consider bringing someone into a position of equity to be special treatment. And she didn't want to lose that. And so she opposed the ERA. And as she was doing work to secure a minimum wage for workers, and a cap on the maximum number of work hours per week, trying to protect workers from exploitation and inhumane treatment, she and others believed that the ERA would be a threat, right? And that it would create this sort of gender neutral position that would mostly hide the sex and gender equity that the ERA claimed to be supporting. And so this rift among women directly led to its defeat year after year after year, all the way until 1973, right? And in many ways, we're still kicking each other out of the sandbox, right? Why are we continuing to do this? And then over the next couple of decades, mostly through the work of the labor movement and the civil rights movement, many of the labor protections that had been won for women were also won for men, and they began to understand that. And so you started to see more support. But even as we kind of celebrate with some anticipation about what could be coming in, I don't know, maybe even the next few weeks, but surely in the next few months or years, we have to recognize that we aren't all affected in the same way, right? What does the ERA mean for Black women and their reproductive rights? right? We've been having a whole lot of discussion about things like this. Black women suffer significantly disproportionately from healthcare disparities, related in some instances to inequitable implementation of laws, right? The maternal mortality rate, for example, for Black women is 40.8 deaths per 100,000 births, more than twice that of white women. Why is this happening? And what will the ERA mean to those women? So if implementation of the ERA looks like current implementation of our public policies, then we're in some real trouble. And we've got to figure this out as we try to get more and more support for what the potential of the ERA could be. Who's going to be left behind? And if we have learned anything from the ERA's past failure, it should be that we have to figure out a way to build a more inclusive movement for sex and gender equity, one that recognizes and appreciates our multiple identities, our experiences, and all of the women who contribute to that. And I will say this in no uncertain terms, the racism and the classism present in women's movements historically and at present, it's shameful. And we've got to fix it. I was thinking the other day about the ERA and a lot of its significance, and started to think about the Seneca Falls Convention back in 1848, where it seemed that there was going to be a massive push for the right to vote, right? But the movement split over the issue of slavery. Right? And it's so interesting. Why is it that white women could not bring themselves to see Black women as their equals? It's because of that they disassociated from the movement, because they didn't want abolitionists involved. Now, I mean, just really think about that for a minute. In many states, white women were considered property of their husbands or their fathers in some cases. They had very few educational opportunities. They couldn't vote. They couldn't hold public office generally. There were a few exceptions. They had the legal status of a child. But rather than work with Black women, whom they considered to be inferior, they chose to stay in their miserable conditions just to reinforce this idea of racial superiority. Again, kicking people out of the sandbox. Why? And partly because of that, it took them another 72 years just to get the right to vote. Because there was no coalition that was powerful enough to push it through. Right? Think about that. Time wasted because we can't get it together. Black women, Latino women, Asian women, Native women, they should never feel they are less woman because they aren't white. What are we doing about that? Women who are poor, women who are working class should never feel that our movements don't relate to them. That our movements aren't about what they want and need. How can we hold up our signs that say ERA now and then tell poor women that we don't support a living wage for them? How can we ignore the immigrant women who are suffering? What will the ERA do for them? Who's chanting, "My body, my choice," for them? right? And so I think we have to really consider how all of this will play out in its implementation and make strategic decisions that help ensure that the ERA and its implementation is not exclusive, that it is as inclusive as it possibly can be. And we can't keep ignoring the fact that the rising tide does not lift all boats, right? We must make very intentional and concerted efforts to make sure those who have historically been left behind get the time, the care, the attention that they need for full participation. The ERA has such potential. I mean, you can get giddy just thinking about the possibilities of what could happen if it is certified. But if it still means that women are going to be left behind, then what have we really accomplished? So those are some of the things that I think about, and some of the things that I hope you also have been thinking about as we figure out this way forward. So I'm going to stop right there. So I want us to have some time to engage and have some good discussion with your questions. But thank you for your attention.
And thank you, Brandy.
Mm-hmm.
I now will turn it over to Amelia Brust for the Q&A portion of the evening.
Thanks, Susan, and thank you both Jessica and Brandy. So just as a quick reminder, if you want to submit a question for our panelists, you can use the Q&A feature at the bottom of your screen, type your question in and hit enter, and we will try to answer as many questions as we can. Questions will display as they are answered. And just as a general reminder, please be respectful of everyone in the audience and respectful of our presenters. So the first question, I wanted to just kick it off with one of my own. It's kind of a technical question. Why exactly was the ERA first written with a 7-year time limit in its preamble? Is that normal? Was that normally done for constitutional amendments? Was it something that came out of the sort of like committee process, the like negotiation to finalize this amendment's wording? Just kind of wondering what, if either of the panelists know what the sort of reasoning or thought process was for doing that in the first place.
I can start. And okay. I think, I mean, so timelines are a relatively modern invention, adding them onto amendments. There's an amendment, they call it the Madison Amendment, which actually was introduced by James Madison and passed in the 90s during the Clinton administration. And it didn't have a timeline. I mean, it's been hundreds of years and that thing got added to the Constitution. I'm sorry, I can't remember which number amendment it is. Someone will tell me, I'm sure. But they're a relatively modern invention. I think it was largely to, you know, try and prevent the amendment from going into effect. I don't know for sure, right? But like it was set specifically with a specific timeline to, you know, to and I think probably to prevent activists from going as long as they possibly could to get the votes that they needed. And it was extended once, and so we had a total of 10 years to pass it, to ratify it. And but it's relatively modern, and you know, there have been few other amendments that have actually, if any, amendments that have actually had a timeline applied to them.
Yeah, I just echo that. There's nothing in Article 5 of the Constitution that says there needs to be a timeline. So you have to question the motive of any amendment that does have that type of timeline. And there had been such a struggle with what it should look like, what it should say, whether or not it was actually going to make it through Congress, let alone 3/4 of the states. But I agree with Jessica. I mean, in the negotiation process, I really believe that people thought it was a sure way to kill it. And it worked for the most part, right? But I've not seen anything in the congressional record so far that gives a definite answer to that question.
Okay. So we have one question from an audience member who worked on the ERA in 1982, I think in North Carolina. And they said that at the time, legislators there were very adamant about not ratifying it. Why maybe is it still considered necessary now in 2023? And I'll just add a little bit onto that question. Do you think people still think this type of amendment is relevant, given how kind of maybe broad its language is, or maybe how many different aspects of gender equality we have come to discuss since 1982?
Yeah, that's a great question. And most of what's behind that argument is the fact that at present, 26 states have some version of an ERA at the state level. And so many have concluded that, well, it must mean we don't need an amendment to the federal constitution because the states are figuring it out and they're going to do the right thing. But we have seen that even in the states that have at least some version of an ERA, there is still inequality, right? There are still problems with the inequity. And so to leave it to each individual state to decide whether or not I get to be equal, I don't think is the best idea, right? The value added for having it in the federal constitution is that it will apply no matter what state you live in, right? This should not be a state choice, right? When we even look at very simple language in the US Constitution that provides us with equal protection, it was clear that it was needed because of what was going on in the states, right? So I think that it certainly requires more than just each state getting to decide not only whether there will be equality, but how much and under what circumstances. No, we should all have that access at the federal level.
I can't say it any better than Brandy already has. When Brandy was talking earlier, I think she made the case for why we still need it, right? We don't have equal pay. Till 1974, women couldn't even get a credit card. In 1920, white women got the right to vote, but it wasn't until 1965 that Black men and women really got the right to vote. And then the Voting Rights Act was amended and added Asian Americans and language and disability, those with disability. And so we know that change is incremental. And without a federal ERA, a federal equal rights amendment, we won't have equality across the board.
Great, thank you. So Jessica, I think you shared in your presentation that the latest polling data shows that about 74% of the public is in support of the ERA. According to the American Enterprise Institute, that's about the same level of support there was in 1974, back when basically it had just been passed by Congress. So the fact that the level of public support has kind of been more or less stable for the past 40 years, is that a good thing or a bad thing? What do you think that kind of says about how enthusiastic the public is for passage of a law like this or of an amendment like this?
So I think it's a good thing that it has stayed stable. It hasn't gone down. We know that politics in America right now are very divided. And that's, that's just the reality of it. But still, whether we have red versus blue or blue versus purple or red versus purple, we still have a constant support for the Equal Rights Amendment of the 74%. I think it's very important. I think it speaks to the fact that Americans, no matter where they live, they want to see people have equal rights and not judged or taken away based on sex.
Okay. So another question from an audience member is that given much of the sort of anti-LGBTQ sentiment that has cropped up in many states, has there been pushback from legislators on the ERA specifically due to any implications for LGBTQ rights? And the one of the kind of common arguments made around the ERA has been from people who say that it could sort of encroach upon sort of single sex settings or environments. And I kind of want to know what you think about those arguments, if you think those are being made in good faith, or if the aspect of gender is something that maybe deserves special attention versus just sex, as the law describes.
Yeah, I think that's a great question to raise because as I have talked to a lot of folks in the LGBTQ plus communities, it is a question that they continue to raise because the language of the amendment simply says sex, right? And one of the first questions that they always ask, what about gender, right? What's going to happen with that? And we know that over the years, there have been certainly some gains in legal rights when it comes to gender, but also a lot of pushback. Right. And I honestly don't know how moving forward that is going to affect us in terms of the interpretation that legislators make and the courts make. You could argue, I think successfully, that the courts have at times used the two terms interchangeably, even when they didn't intend to. And so maybe sex could be broadly construed. Others say, no, what it might do is focus too much on biology to the neglect of identity. And I really don't have the answer to that. It's one of those things that we'd have to see how it gets implemented. Somebody would have to sue and then the courts would sort it all out. And that's really the only way that we would get a definitive answer. Some have argued that before pushing forward with trying to get the ERA passed, coming out of the 1970s, it should have been revisited and the language should have been changed. I think it's a fair argument to make. But again, would that have made a difference? Would it have helped us to build a broader and stronger coalition? Maybe, but I really don't know. So it's a great question. I just don't have the answer to it at this point. I just don't know because so much of this, I think, will be figured out after it takes effect, not before.
Yeah, I think it'll, in addition to implementation, it'll also depend on judicial interpretation. I'll say, Phyllis Schlafly, who Brandy mentioned earlier, was one of the major opponents of the ERA, and that's an argument that she used to, get people to not support the ERA. But we already have bathrooms that are unisex bathrooms, and everyone's okay. Like we already have some of these like same sex spaces that exist. And I mean, it'll really depend on implementation and judicial interpretation, but giving the ERA is another tool that the courts will be able to use to interpret, just how far discrimination is going.
Yeah, I think it's hard to predict how creative lawyers of the future will be in interpreting laws that maybe at the time are written in what is thought to be a very broad, all-encompassing way, and then in time are used against their original purpose. So I can see why it's really hard to sort of account for all possibilities in language that is supposed to be very simplistically written like a constitutional amendment, so you can apply it to a lot of different situations. We have a question from another audience member. Can you please explain the issue of states that have voted to ratify and then later voted to rescind their ratification of the ERA? I think Idaho was maybe one of them, for example.
So the National Archives says that once the National Archivist has certified state ratification, it's final and conclusive. States cannot rescind. You cannot take it back. And rescission attempts for other amendments, like the 14th Amendment, have not been recognized, and the courts have ruled that rescissions do not apply. So I think that's the simplest answer I can give. Once you send it to the National Archives, you can't take it back.
I echo that. There is no provision in Article 5 for rescinding a ratification vote. But I think what matters even more than the legality of that are the political optics, right? And so what has happened, unfortunately, is that people have used these very public rescissions and it's 5 states at this point that have voted to rescind. People use that as a way of saying, see, wait, we need to slow down. We need to revisit this. Why are these states rescinding? There must be something wrong with it. What are we doing? And so it serves its political purpose, which is to lose momentum, right? As people try to figure out what are all of these political tactics and why is this happening? So even though there certainly is no legal basis for a rescission, it serves a very, very important political purpose.
Susan, I think you actually had a question that you wanted to pose to our panelists.
Sure. I, having been decades in favor, I finished college in 1972, and it was not too long after, and coming along, caring about it, acting in the moment to figure out what might be the most practical expedient, the most positive ways that we can move ahead. I am wondering now, in 2023, Jessica and Brandy, what you think of as the most positive things that we can do right now, actions that we can take.
Well, I started with a few in my presentation. I think we live in Maryland. Well, most of us live in Maryland, right? And we have, some pretty good senators and representatives who already support this. But I think it's important to talk to your friends and family members who don't live in Maryland, who might live in other states that still need to ratify, and continue to urge them to push for ratification in their states. I think it's also important to work in the states at the state level that don't have a state level ERA. One thing that we talk about with voting rights all the time is that when we see good policy reforms work in the states, gives them a better option of percolating up to the federal level and then being applied broadly across the entire country. States are real testing grounds for not only democracy, but also for other policy reforms. And then I guess the other thing I would say is, if you also have an opportunity to do something at the county or the city level, municipal level, to encourage your county and municipal level governments to support equality, and then send those on to your federal legislators. And it's really important to continue to build the momentum for equality and for support for equality all across the country.
I really believe that the most important thing at this point is the grassroots work. Talking to your neighbors, talking to the people around you, discussing why this is important and what it's designed to do. It was that kind of grassroots work that made people turn their heads, right? When Nevada says ratified, right? When nobody had really expected that to happen, because in most of the public's mind, this thing was gone, right? 1982 came, hadn't been ratified by the appropriate number of states. And so people said, well, must be gone, right? But the grassroots work never stopped. People were still out there trying to make people understand why this had to happen. And it directly led to those successes in both Nevada and then in Illinois. And I can attest to the fact that it absolutely was behind getting Virginia on board, right? Nobody expected that Virginia would become number 38, right? But it was because of the solid grassroots work that was being done, even when the cameras weren't around. And I think that is the approach that we must continue to take. One person at a time, neighbor to neighbor, friend to friend, discussing why this is important.
Somebody was talking about North Carolina earlier, and I was like, I know a group of people in North Carolina who are still pushing for the ERA, despite the fact that the North Carolina legislature has never ratified it. I know there's a group of people, and I think Brandy's right. Grassroots power is so, so important.
So if there is somebody who maybe lives in one of the states that hasn't ratified it, I guess it technically isn't necessary for that state to ratify it at this point, but grassroots support, can drive national change. What are some maybe more nuanced ways you both would recommend people talk about the ERA? Because I think it was Jessica, you said that, we need to talk about this in a more nuanced way. And Brandy, you talked about how, implementation will really prove the merit of this if it's ever actually going into effect. So, there may be a case where people bring this up to their friend or their family member or something, and maybe the response they hear is, I'm not sure the full scope of what it is, but wouldn't that mean that women would have to be drafted? And that is the sort of, bumper sticker catchphrase that they do know. And that colors their opinion of the whole law. So what are maybe more dimensions of this issue that you think we need to talk about more, so that that broadens the understanding of what this law means for women and men and non-binary folks.
Brandy, I was going to let you take this one.
Okay, sure. Yeah. So I'm a huge fan of discomfort. I believe that when you're talking about something that is this serious, you've got to be honest, you've got to be open, you've got to admit what you don't know, but commit to trying to figure it out. And you've got to be able to explain it to people in a way that resonates with their positionality and their lives. It should come as no surprise to anyone. People are going to ask, well, what's in it for me? How is this something that's going to help me? How does this affect me? Is it going to harm me? And we have to be open and honest about the possibilities. There is still so much that we don't know about how all of this will work out, but we should be having those conversations. And if somebody says, well, is it possible that I could be drafted? Yes, that is a possibility. That is an honest possibility. And why is that bad, right? We have to push. What's behind this? We have seen so many women coming into military, enjoying careers in military. Why is it that this is still a fear point for women? What's behind that? Let's have that open, honest discussion. And I think too often what we do, and I think it's part of the reason why Shafley was successful as she traveled the country talking about this, is we were too dismissive. We simply dismissed it. Oh, don't worry about that. No, people are worried about it, which means we have to worry about it. And we have to be willing to have those kinds of often difficult discussions and then see where we end up. I don't think that we can afford to keep talking only about the things that make us comfortable, talking only about the things that we consider to be positive, without addressing the concerns that others are bringing. It doesn't work. It just doesn't work. So we've got to get in the WWE ring sometimes and go a few rounds on these kinds of issues and see where it all ends up.
And for the 12 states that have not yet ratified the ERA, we still need them. Even though we don't technically constitutionally need them, they can still ratify the ERA, and it's still very important that our activists on the ground and that our legislatures and the people who make those decisions about ratification move towards a yes, because that's the only way we're going to continue to push and put pressure where we need to put pressure to get this finally included in the Constitution.
Great, thank you. One of our audience members asked if either of you watched or attended the Senate Judiciary hearing on the ERA back in February. If you did, are you able to kind of describe what you observed, what the debate was like? If it seemed like at this point, these new motions being introduced actually stand a chance in this current Congress?
We are in a very divided Congress. I don't think it's impossible. I don't know that it will be possible on the first round in the vote in the Senate this week. I did attend the hearing in February with one of my colleagues, Rebecca, and there were two panels at the committee hearing. There was one with a couple of Republican senators who actually spoke out against the resolution. One of those being Sydney Hyde-Smith, who has a resolution against in opposition to SJRS 4, which is coming to the floor later this week. But then there was a very good panel, I think a very good divided panel of both minority and majority witnesses that spoke about the constitutionality, spoke from why it was needed, why they didn't think it was needed, what it would do, what it wouldn't do. There were some outbursts from some supporters in the audience, which was, I mean, it's been a while since I had been to a committee hearing, but it's a new day in Congress, it felt like anyway. But I did think that the panel was very even. I thought that there were some really great questions from Senator Durbin, from Senator Hirono, from Senator Klobuchar. And then there was, some skepticism thrown from the minority party in the Senate, the Republicans in the Senate. But I think, they're all just trying to get to a better understanding on what the ERA would mean for the country if this resolution was passed and the Senate affirms that it is part of the Constitution.
Okay. Thank you. Our next question that I want to pose from the audience, do you think passage of the ERA would affect reproductive rights for women in any way?
The Supreme Court spoke on that in the Dobbs decision. And then I think that states have subsequently been passing laws or putting the question to voters about reproductive choice. So I think that question has been answered at the federal level for now. And I think states are continuing to answer it for their residents and their citizens. And I think, I don't know if the ERA will have an effect on that, but I do think that it's been answered for now at the federal level, and states are working to address it.
I think that it could, right? Basically, what the court would have to answer is whether denial of an abortion constitutes sex-based discrimination. And if they conclude that it does, then it would be a violation of the ERA, right? So this could be very significant for that, or it could mean nothing at all, right? Depending on how far the court is willing to go. We have some indication through case law prior to the Dobbs decision that this could very well constitute an unconstitutional sex-based discrimination, in the same way that the courts during the 70s and 80s determined that sexual harassment was actually a form of sex-based discrimination, right? So broadly construed, this could be very, very significant. And as part of the Constitution, if it is certified, of course, I strongly believe that the court would have to come back and reconsider the Dobbs decision.
Thank you. So for those who want to follow the ERA hearing this week, where can they do that?
So it's not a hearing, it's an actual floor vote. We think that Senator Schumer is going to file for cloture on the motion for cloture tomorrow. So then that would mean that they would have 48 hours before they vote. So vote probably on Thursday sometime before the Senate goes out of town for the weekend. And then there's some question about when senators will stand up and speak to or against the amendment. That might happen on Wednesday. So I would say to pick up your C-SPAN or get the YouTube live of the Senate floor sometime on the afternoon of Wednesday, and stay tuned to news from the League and to news from the ERA Coalition, who will be sending out updates and directing folks to where they can watch what's happening.
Great, thank you. So we've got about 10 minutes left. Just a reminder to attendees to, if you've got any final questions that you want to ask, make sure you put them in the chat. Wondering if passage of the ERA as it is now could actually give more foundation for maybe more specific protections to be written into federal law, or could give more standing for specific, programs, maybe like from executive agencies, to provide protections for women on issues that disproportionately affect women or disproportionately affect women of color or older women or pregnant women. Kind of what, because a major argument has been that it wouldn't do that, it would do the opposite. But I'm actually wondering if having that baseline of a constitutional amendment actually can help spur more specific laws or programs aimed at more finer tuned equity in the law.
So I'm not really convinced that that is the case. And the reason why I say that is because Congress already has very broad legislative authority under Article 1. There is so much that Congress can do that it doesn't do, right? And I don't think that the ERA sort of grants permission to Congress to be able to do more. I think what the ERA would do is help to sustain the legislation that Congress does pass if it chooses to do so. And to me, that is the value of it, right? It doesn't necessarily require Congress to do more. Congress can do a whole lot. But the ERA would provide the basis for upholding many of the laws that Congress could pass.
Great, thank you. An audience question we've got is, would a proposed amendment maybe stating that the Equal Protection Clause of the 14th Amendment shall apply under all jurisdictions of the U.S. without regard to gender, if that could possibly be a more successful effort going into the future, or if that is something that maybe could complement the ERA, maybe.
So it's certainly an interesting question, and I've actually thought about that. The problem is that you don't get any delineation in the Equal Protection Clause of any protected class, right? So it doesn't mention exactly who or what is going to be covered, and the courts have had to figure that out on a case-by-case basis. But the problem is in the way that they're figuring out, right? There are different levels of analyses based on the type of discrimination. And that has actually helped to perpetuate some of the sex and gender-based inequity. When you say, well, we are not going to elevate gender, for example, to the category of intermediate scrutiny because we don't think it's the same as an analysis based on sex, then you automatically position one class of persons below another. So I'm not entirely sure that writing gender or sex into the Equal Protection Clause would have that effect. It could, but I don't see any evidence, at least for now, that it would. It's a great question to think about, though.
Great, thank you. I think we have time for maybe one more question. This one's also from an audience member. So, if the ERA were to actually pass now, how do both of you think it could affect your rights personally? So this might be a bit of a personal question, I guess, depending on what you both got going on in your lives, but do you see a way that this could directly affect you in your own life at this point?
You can go first. For me, I think I think about a lot of stuff when I think about the ERA. But I think one of the things I think about most is how lucky I am to live the life that I live, but that others don't have the same rights and responsibilities as myself. I'm a white woman in a very affluent place and county and area in the country, but I know that that there are Black women down the street who don't have the same rights and access to affordable health care, to wage paying jobs that I do, and so it's not when I think about it, it's not really of me I think about. It's all of the other folks around me who I want to be able to enjoy the same rights and responsibilities that I have. And that's what equality and equity and racial justice means to me. And that's why why I think the Equal Rights Amendment is one of the most very important tools that we now need to continue to fight for equity and equality across the country.
I would echo that. I think one of the most important ways that it would affect me personally is through what I think would lead to the elevated scrutiny, meaning that government and states particularly would have to have a compelling reason for any sex-based discrimination. It's an extremely tough standard to meet. And it would mean fewer discriminatory laws would be upheld then. The weakness, though, to me in all of that is that we still have not dealt adequately in the arena of private-based discrimination. And the ERA would not necessarily touch that type of discrimination. And I think we would have to do a whole lot more to make sure that private entities are also not discriminating. But in terms of discriminatory policies by government and the states, the ERA would most certainly mean that we would see fewer of those types of disparities, because those types of policies would simply be struck down. And that would be good, not just for me, as Jessica was saying. It's about so much more than that. It's about all of the people who are still suffering, and what it could mean for them. Yeah.
Well, I would like to thank you both. I think for the prompts you've given personally to me, reminders of the need for action, suggestions of what we can do right now, a reminder again of the importance of facing conditions and ideas and situations that make us uncomfortable. We need to do that. And I have to say, I hope to be giddy with success on this one within my lifetime, because it's been a long time, and I just want to say that personally. That is all the time we have tonight. Really heartfelt thanks to our esteemed presenters, and thank you for everyone who joined us tonight. If you enjoyed this free program and want to learn more about the League of Women Voters and the work we do in Montgomery County, you can find out more about us, including how to support our efforts at LWVMOCOMD.org. With that, we will say thank you again and good night.